Okay, so let's go back to, we only have about 13 minutes remaining in today's class meeting, but we can at least get started on this, and then we'll get into it heavy next week. Okay, what?
We talked about the video.
Yeah, I mean, we sort of started with that video last time, introducing you to some of these things. So this is not going to be new. It's not going to be like you haven't heard of these things before. But now we're going to get into some of the details. Okay. All right. So I want to begin by talking about this exclusionary rule that they were dealing with in that program last time. And you may remember at one point when they went away from the panel discussion to Justice Potter Stewart. By the way, former Supreme Court Justice Potter Stewart. I told you that there were a lot of heavy hitters on that program. Obviously, Potter Stewart would be one of them. But the guy who was talking to him, who was sort of, his name is Fred Friendly. And if you've never heard the name Fred Friendly before, if any of you decide to go into broadcast journalism, you should know the name Fred Friendly. Fred Friendly is a pioneer of broadcast journalism. It was actually portrayed by George Clooney in a movie a few years ago. George Clooney was Fred. Can you believe that guy George Clooney turns out to look like Fred Friendly?
Which one was that?
Fred Friendly, the guy who kind of looked like the Muppet. You know, was the older gentleman who was talking to Potter Stewart, asking Potter Stewart.
At the table?
Yeah,
Oh, okay.
yeah. I'm just saying he was a pretty big deal in broadcast journalism. He's deceased now, but he was a pretty big deal. At any rate, there was a point in the discussion between those two gentlemen where Potter Stewart said a decision of the Supreme Court almost 70 years ago. Well, remember, that program is now 40 years old, right? So we're talking about over 100 years ago. The precedent-setting case, as it pertains to the exclusionary rule, actually goes back to 1914. This case, Weeks versus the United States. That was the initial case where the Supreme Court held that evidence found by the police in violation of the Fourth Amendment provision against unreasonable searches and seizures could not be used in court to obtain a conviction against the defendant. Now that case, that Weeks case, involved federal law enforcement. I believe, if I remember correctly, I really need to go back and refresh my memory on this particular case. If I remember correctly, it involved a guy who had been selling lottery tickets to the United States mail, which was a federal crime. And therefore, he was prosecuted by federal law enforcement and convicted in federal court. But in the process of all that, he had some of his property confiscated by federal law enforcement, and he claimed that it was an unreasonable seizure, and the Supreme Court agreed. And furthermore, held that the evidence that the police obtained through this unwarranted seizure, this illegal seizure, was not admissible at court to obtain a conviction against Mr. Weeks. Okay? So initially, that's why this case is important. That's the case that Potter Stewart was referring to when he said almost 70 years ago. And remember, he said, not a snivelingly liberal court. I think that's a hilarious expression. As if somehow, if you're liberal, you must be sniveling. Not a snivelingly liberal court either. It was a court that was relatively conservative, he says, that handed down this decision that said that the government can't use the evidence in an illegal search and seizure against the defendant. Okay, so that's the origins, that's the birth of the exclusionary rule. Now, that was a case involving federal law and federal law enforcement. Okay, and remember that the Bill of Rights, and that includes the Fourth Amendment provision against illegal searches and seizures, unreasonable searches and seizures, originally applied only to the federal government. It didn't apply to states. It took another 50 years, okay, for the United States Supreme Court to say that that right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures is also protected against the authority of state and local law enforcement. And that happened in a case called Mapp versus Ohio. We don't have to get too much into the weeds with these cases, but I think this one is interesting. Have any of you ever heard of this case before? This case involved a woman named Dolly Mapp in, I believe, Cleveland, Ohio, one of the major cities in Ohio anyway, who the police arrived at her home with a search warrant that indicated that they were looking for evidence in a bombing incident. And they executed the search. They didn't find any evidence related to a bombing incident, but they did find materials that they deemed under Ohio law to be obscene. And so they arrested Mrs. Mapp for violating Ohio obscenity laws. She was convicted and given a sentence, and she appealed her conviction on the grounds that it violated the Fourth Amendment's provision against unreasonable searches and seizures. Remember that the Fourth Amendment says something about, go back to it here real quick. It says something about, I said 14th Amendment, I meant 4th, okay? It says something about describing the place to be searched and the person or things to be seized.
You can't just go in there looking for one thing and grab another thing.
I was going to ask you that question, right? What do you think the framers of the Bill of Rights had in mind there? And, I mean, it's so long ago, could they possibly anticipated these kinds of circumstances? But I think you're on the right track, right? That this is really intended to prevent the government and its police power from going on what we might call today a fishing expedition. Let's just go in and look and find something, right, against this person, right? So the search warrant is supposed to specify what they're looking for, what they expect to find. And in order to get that warrant, the judge is going to have to make a determination. They're supposed to have to convince the judge who issues the warrant that there is a reasonable probability that they're going to find what they say that they're looking for. And if the judge doesn't believe that they're not going to do it, they're not supposed to issue the warrant.
So that could be used receptacle a lot from maybe if a cop wanted to incriminate someone using fake evidence.
That is true.
Things.
They could just.
Well, maybe, but
No, you have to convince that there's a judgment that's reasonable. Reason that person would have that, and if they don't.
yeah, but remember, we're talking about physical evidence here. When the police do a search, we're not talking yet about statements. We're talking about the police going into, in this case, a private home and looking for physical evidence in a particular criminal act and not finding it, but then finding something that they could use against her.
So in the case of that video with the shrine and the rose, which is rosary on the shrine. So you have to be very specific when you get your warrant. Like, this is what we're going to look for.
I'm not a lawyer. I always have to preface what I'm saying. I'm not a defense lawyer. I'm not a prosecutor. I don't have the kind of background. I'm not even sure that there would be a consensus, though, among those who do have law backgrounds. I think it's very murky. But, again, I think that's why I said earlier that these things tend to get worked out on a case-by-case basis. Maybe deliberately or not deliberately, the police push the envelope, right? And then it has to be tested. It amounts to a test case. Oh, well, we've never dealt with this question before, right? Maybe they obtain a conviction. Maybe they execute this warrant, and there's some issue that the defense wants to. Hey, that's a violation of the provision. It should have been excluded at trial. It's just hard to say. You kind of have to work these things out, individually.